Hello everyone, welcome to An Hour With LawSikho. Today we have with us Mr. uh, Devashish Jagirdar. He's a criminal lawyer. He's a litigation lawyer. He's done civil and arbitration litigation. So let's just get right to it and introduce you to Mr. Devashish. Hi Devashish.
Hi.
Yeah.
So I have been working with Jayakar Partners for the past 4 years almost. I got into this after I passed out. As far as litigation is concerned, I was working with an advocate earlier, and now I am with Jayakar Partners as a senior associate. So, as a part of my job, I look after civil, criminal, and commercial litigation matters, mostly in the Bombay High Court. A few of my matters are in Jaipur, are in Ahmedabad and Chennai. So, yeah, that's about it.
Yeah. Great. Devashish, we'd like to know something about you. Like, what got you into law, and how did you come about this career?
Law. I was into model events in school a lot and debates. So yeah, if you are anyways debating, why do it for free? That
That's
was the
right.
question my mom used to ask me. But then yeah, ultimately I chose a career that makes some money out of it.
That's a very wise career decision. So, how was your journey through college? Like, what helped you become a lawyer as you are today?
So, starting on from ILS, which I got through first, I got through GLC also, but I chose ILS because of the college life over there. So, in ILS, there is a lot of time to, do a lot of other stuff. After the 10 a.m. lectures get over, you have the entire day to you. So, the first thing I did was get into dramatics because I was into drama in school. And I got into dramatics, but and there I learned that if you can convince a 300 area crowd, you can definitely convince the judge. Parallelly, I did model events, which I did in school also. So in college, model events were a different arena altogether, because in school you used to do as a innocent person to win collectively as a school. In college, the ball game was different. Since colleges didn't allow participation through the entire university, you had to be represented individually, and that's what we did. Represented ourselves in a committee individually. Oh, before I get on, I had to explain MUNs to everyone. MUNs is a mockery of the United Nations, in which you sit as a delegate in a specific committee. Say, for example, UN Security Council. You sit as one of the 15 nations selected at that point of time, and if you're an experienced model UNer, you ultimately sit as the top 5 nations. And you debate on topics which are of concern at that point of time, agenda specifically as they are called, and that's how it is. I mean, that's what taught me a lot of skills of becoming a lawyer.
Uh, could you just elaborate a bit more? How does that work? What is the whole system? Like, if you could break it down in
So base,
the immune knowledge.
yeah, I got a question. So model UN is basically debating, but it's an organized form of debating. There are three forms as you go through a model UN. There's something called as a speakers list. There's something called as a moderated caucus and an unmoderated caucus that you go in a model UN. So if any debate, if say two people are arguing at the same time, it's not really a fruitful conversation. That's why United Nations designed this entire spectrum for a proper hearing of everyone's issues. So there's a speakers list where one speaker of each country talks in about whatever specific period of time, and then ultimately concludes his stance on the topic. Say, for example, terrorism. Every country would have their own stance before the entire forum, and they talk in that speakers list. It's basically one to one. It's basically one on all. And then after that, there is something called as a moderated caucus, where a specific agenda is drawn up, and anyone who's willing to talk or anyone who's willing to participate in that agenda raise their placards and they start talking. And unmoderated caucus ultimately a, a debate with the entire committee, where you are in fact yelling on top of a chair, shouting for votes, shouting for people to come on your side or of the agenda. I mean, it was in a way very, very much a lot fun in school. Through college, it became a bit more serious. So, are you getting the structure as far as I'm talking about? That's how the structure
Yes,
is
more or
basically.
less. Yes. So you were into a lot of. How do you see these activities helped you become a better lawyer? Like you said, obviously debating not for free. That
Yeah,
goes
yeah.
without saying. But apart from this, how did it? Does it help you in reasoning?
Yeah, it
Reasoning.
is. It does. It does. It does. Now, I'll tell you how it does. So, this takes back to school directly. So, I was in seventh standard, and I had to represent Indonesia in an illegal trafficking agenda. And what I did first was research, which every lawyer would do as far as reading his research, reading his case briefs are concerned. So I read the law and the stance that Indonesia has on illegal immigration, illegal trade of sex workers, and all of that, which obviously is a part of your legal career as a lawyer, research. And as far as model events goes, that would go in two sides: research as far as the topic is concerned, research as far as your country's stance is concerned, which is as far as the foreign policies are concerned. Equating that with what I do right now, I research on what my matter is about, what laws are in fact in it about, and what would the stance or what would the strategy of the country be. After research, the second stage in a model event was about research papers or policy papers, as some model events called them. So those were actually some of the stances that we take as far as those agendas are concerned. Linking that to the law career, you write something like a reply, or you ultimately go for filing a motion, filing a suit, filing a writ petition, filing a complaint, or any of that sort. Basically, the strategy in which your client would go ahead is something that a modeler taught me. Okay, this is what my country would say at that agenda, and this is what my client should do in today's scenario as far as his reliefs are concerned. Now, the biggest thing, probably the biggest thing modeler taught me was patience, because again, taking me back to seventh standard, I didn't know what was going on, and patiently listening was the biggest art that a model learner, that a person who argues, that a lawyer would get. And taking back to like just yesterday, when I was sitting in court for the entire day, waiting for my matter to come, that's what gave me the most patience. Sitting, observing what is going on, what is entirely the spectrum. Because just as lawyering skills, no one really spoon fed me lawyering skills. Modeling skills came to me by observing my seniors, my colleagues, my friends who were doing it better than me. So that's how I learned Modlu, and that's how I learned the art of advocacy. Uh, Moving on, the third step in a Modlu was ultimately drafting the stance on the agenda and submitting that research paper. Now, most model UNers in today's era carry iPads, carry agendas, carry hundreds of documents. We were the old school ones. We were the ones who couldn't afford iPad at that point of times. So we used to carry all of that written notes and everything, which I even today do. I mean, then comes that stage of a lawyer where you study your matter, where you make notes, sitting on your desk or on your comfortable chair, and write them down on a piece of paper. That was that was the pre that was the preparation before the argument began. And now coming to the argument part of it. In a model event, the most important part was when to say what and when not to say what. So I will equate this in a way that links to the current lawyering scenario in our country. In model events, there are speakers list where you get your own time to explain your stance on the agenda. There is this something called as moderated caucus where you limit the agenda to a specific detail and you talk about it with other people. And there is an unmoderated caucus which is ultimately like our Indian parliament, where we talk, where we throw stuff, where we in fact gather around crowd. So now equating this with today's scenario. Today, if I have, say, for example, a petition filed against my client, I go in court on the first day seeking the opposition of the ad interim relief or the interim relief that he has sought for. That is me preparing for the stance that I have on the matter in the most precise manner, in which the judge is convinced that, okay, fine, what he's saying is right. Let's give it a proper hearing. That's what today's lawyers in a day and age, as far as civil matters would do, is the case. As far as criminal will go, the same thing would apply into filing a complaint or opposing a complaint. And that's what MUN gave me a parallel to. There was a bit of organization in it, there was a bit of patience in it, but conveying your point to the chairperson over there and the member committee over there, vis-a-vis the division bench or the single bench judge that you have in the high court. And that's what I mean. Every time I possibly even mentioning is something in high court, that has to be very precise and very, very target based. I would say tomorrow I'm mentioning a matter which is an appeal. Now when I'm going to a judge, he obviously knows what assignment he takes. Similarly, in a model UN, you exactly know why you're there. The agenda is set, the limited powers of that committee are set, and I'm just trying a parallel over here. So all you have to say is that precise thing. I am here for what? I am here for these ABC reasons, and that I am trying to get from this court. So that was the most important preparation and first baby steps to model UN. Now, obviously, getting into the hang of it, getting into the modalities of it, I had to research on the agenda enough to really prepare a resolution altogether that would reflect the the stance, the measures, and the solution that country would take on that specific agenda. Now, coming back to seventh standard, where I was clueless about all of this, I didn't utter a word. I didn't utter a word. I was observing. I was just being on a hearing position where I would, okay, America is doing this, okay, UK is doing this as an agenda. Okay, yeah, there's my friend who's Malaysia. I think I should take his stance because of Indonesia. So probably that was something when I was clueless. And this takes me back to the first day I actually went in court. This was Delhi High Court, and I was an intern. Obviously, I didn't have to speak. So I was seeing what the lawyers over there were actually seeking relief for, and it was a 2-minute job. They go appear before the judge, say something, the judge just understands it. Some orders get passed to a observer who's looking at a model UN and a courtroom. He would think the same, that nothing's happening, that all these guys are just over here speaking normal things which I can't understand. However, as far as model UN would go and as far as the court would go, things go in an orderly fashion. That's what wasn't a, that's that wasn't a surprise for me, since I had seen this in a model UN scenario. So okay, this will happen in a stage. Okay, fine. So when I convinced myself, when I went to Delhi High Court, I went to a civil bench which I knew there was, which was a suit bench. So okay, this is a suit, and I would make notes in my head. Okay, this is for evidence. So now the High Court would appoint a commissioner, and that commissioner would have to be extended time to time, and that's how I grasped my knowledge of law, because I had done model events earlier. So that's what helped me the most, as far as knowing a structural form of debating vis-a-vis the structure of judiciary and the structure of any matter that goes in a court. That's what helped me the most. So going down to the next stage of a model UN, where we actually made resolutions and asked for suggestions and all of that. Now that is, of course, that you can't really have in a law scenario, but I mean, equating it to the largest extent in some arbitrations, some parties have common reliefs. So that's how you attain, in a way, the majority and convince the other opponent of yours that, if this matter moves to this direction, we both have a win-win situation. And that, for example, if I would really bring into that basic agenda and link it to the modeling, to the lawyer scenario also, finally, after the second day of model UN in my seventh standard, I got up as director of Thailand and said that, okay, fine, even my country faces this big basic issue of illegal sex trade, all of that. Let's put a tab, let's put a measure to it, let's have census taken, let's have something, some kind of a common agenda that every country can adopt. Vis-a-vis bringing that to the scenario of arbitration where I am representing a battery of builders before a forum which is ultimately going to decide their fate. So I bring all of them together, think that okay, fine, this is the proper relief that you're going to go because you are a firm and you're a partners in the firm, and that's how you're supposed to go for it, so that the building work completes, so that the flats are sold, and so that your project goes forward. That is something which a model UN also taught me. Bringing by deliberating common views and putting them down on a piece of paper so that you can ease the judge or the chair to pass an order that is a win-win for all. You get what I'm saying? And ultimately,
Yes.
which brings down to the fact that all of this required interpretation of law. All of this required reading the UN Charter, reading the ICJ Charter, and all of that. And vis-a-vis reading the Constitution of India, vis-a-vis reading the Civil Procedure Code, Criminal Procedure Code, Arbitration Act. So the boundaries in which the judge or the member would or can exercise his jurisdiction was the most important part of interpreting the law. The law remained the same, the principles remained the same. The interpretations, obviously, from that childhood memory to till this date, remains a lot. So yeah, that's about model UNs, and as
Great.
far as bearing, yeah, sorry.
So from what I understand, it basically helps in more or less all the skills that a lawyer needs. Like when you're
Yeah,
writing the arguments down, you are doing the working over that. Then when you're framing your issues and anything like that, and then you're going forward, and so it totally builds up to the whole skill set as a
exactly,
lawyer for you to
exactly.
go forward. So while you're pursuing MUN, were there any other activities which intrigued you or which you wanted to pursue?
So, whilst doing this MUNing in college, while I had done some 20 model events, still I was doing this in college. In the second year, a senior of mine interested me in parliamentary debates. Now, something as far as parliamentary debates was, I knew how they are. I always saw parliamentary debates. I hardly participated in a few. So I knew how it goes about. I knew how it ultimately functions, but I had to teach that to a lot of students. So I attended a few seminars here and there. I saw a lot of YouTube videos with low streaming that point of time. This is the second year of college I'm talking about. So parliamentary debates brought me to a new perspective altogether of arguing a matter. Now, a perspective that PDs gave me as far as model events is concerned is that a lot of research. In model events, you have tons and tons of pages to read on on a smallest topic that you have. In parliamentary debate, you're just given a topic. Like, for example, this house believes that homosexuality has to be legalized, and that was a topic where you get some type of preparation, you accumulate your thoughts, and you directly start on the topic. Now, the conventional American or European style of parliamentary debate would have a 4-4-2 or a 4-3-2 mechanism, which is the prime minister would talk for 4 minutes, establishing or interpreting the topic. The Then the opposition prime minister, the opposition minister would destroy that scenario for the next 4 minutes. After which, the deputy PM would step in and would lay the foundation even more for a constructive debate, which is a constructive prime minister. And then the opposition would come and destroy the constructive, and there would be a whip. Now, the functionality of a parliamentary debate would obviously be a bit similar to a scenario in a lawyer. For example, if you are in a court and your opponent counsel throws a random ball at you, which you probably are not prepared for, but you've read it. You've read your papers, you've read your brief through, and something randomly comes in. So that spontaneous thinking and strategy framing at that point of time, in fact, to save that part, was something that parliamentary debates taught me. So, giving you a live example or a live scenario, where something like a contempt arises suddenly in court, and you have your client nowhere to question or nowhere to really ask for, you apologize to the court that this is what it is, this is what has happened. But however, you can interpret this clause by not saying that this is actual contempt. So, in a parliamentary debate, when a prime ministerial candidate or the prime ministerial speaker would establish and shape a topic to really sideline the debate and establish his own favor, the opponent would destroy it by interpreting in a different way. This game of interpretation, as I used to call it that point of Jugalbandi, this game of interpretation ultimately is something that lawyers do in court, interpreting the laws in a different way which they are favorable to each other. So that's what at least parliamentary debates taught me. And of course, whipping was one of the most interesting positions in a parliamentary debate. You have 2 minutes, as a whip, and you destroy the scenario, and you have to mean, you have to be sarcastic, and that's how a parliamentary debate, really helped me. I did a very few parliamentary debates, but yeah, that's how it helped me.
Great. That brings me to the next part of the conversation. Apart from parliamentary debates, what would you suggest? Which kind of activities do you think helps a, litigation lawyer or a lawyer in general?
No, these would be model learning and parliamentary debates would be the ones that are mostly non-law related. Like, you ideally are not going to study international until and unless you are aiming to go to a United Nations as a delegate or as a representative or as a helping subordinate to the United Nations. Only this scenario would help you there and learning about this. But this in a way helped me as far as making of a lawyer is concerned. The making of a lawyer obviously would help you as far as law-based activities are concerned. Like, a lot has been spoken about moots, mock trials, client counseling, legislative drafting, negotiation. I think negotiation challenge has not been covered. So I'll start with moots, which basically give you the entire same perspective, which ultimately you have to argue a case, right? As far as moods are concerned, what participation in mood taught me was that first training required was for IRAC rule. The first training that we as students got was IRAC, which basically is issues, rule, argument, and conclusion. So anytime you're approaching towards a scenario, I think about the IRAC rule that, okay, fine, this is the issue, this is the law behind it, this is the argument that I should put, and this is what I would conclude for it. So this IRAC rule, in fact, cleared the mooting scenario for me, and this is how you should crack a moot as far as any issue is concerned. What secondly moots taught me the most was formatting. Like, hands down to the people who have learned moots without formatting their memos. Memorial formatting was the biggest task in a moot, and how to ultimately bring small pointers so that your draft looks presentable, proper, and with all of those bibliographic notes. That's what moots helped me the most with. And coming down to the major thing was, most moots give you a prayer that you have to fight for this. However, in our novice moots in ILS, we never were given a prayer. So we had to frame the prayer ourselves. Then ask the question whether a judge would be inclined, or moreover would have the power to grant that prayer. And ultimately, framing that prayer was the most important part in a moot, because your your entire argument or your entire memorial would be based on that, framing that one prayer or the two prayers which you ultimately want. Right?
Yeah,
Making myself clear?
true. Yeah, I totally get it. Like, in my first mood, I had no idea what I was going to do, but we just had a simple structure and a sheet with instructions. And the formatting, I always took it lightly, but in real life, I figured out it is of utmost importance.
Oh, it is. It
And
is.
then, yes,
Oh,
and
let
then
me just cut
trying
you
to,
there. Sorry. Yeah, let me just cut you there.
yeah, sure.
Also, another thing that nothing will teach you ever in your life is that in lower courts or in mostly criminal courts, you have to sit down and write an application, even in today's day and age, by hand on a green piece of paper and put some court fee stamps on it. That in that point of time, you also have to keep that piece of paper formatted, even if it is an adjournment application or an exemption application or something like an application for ad interim reliefs which you want at that point of time. Today's day and age, courts allow you to do that. Lowest courts, of course, writing on a piece of paper with your pen and paper. So I would really request each and every one of you to improve your handwriting because I learned it the hard way. The papers that you are as far as University of Pune students are concerned or Bombay University students are concerned, you need to get your handwriting right for this very moment. You're sitting in front of the court and the judge asks you to make an application. You cannot scribble through it. You have to ultimately have a proper handwriting. I would suggest block letters because the judge gets it. But that's one thing that I also that no one taught me. But uh, again, I was judging a mood one point of time, and this is an ILS only. And one of these guys couldn't probably afford a computer or something, so he drafted a memorial by hand, and that's what that effort and that commitment towards a problem really got me, and that was like wow, I was very impressed by that guy. Ultimately, he did make it to the finals, but I mean that's what I just remembered for a second. So yeah, I have judged these
Yes,
competitions also. So as a judge, what you need to expect and what you need to deliver the next time also became clear. So I remember one of these seniors, while again, since you're talking about moods, I went to him, ki, Bhaiya, how do you go about a mood? I've never done a mood before. I've done a man before. I've done a debate before. I've never done a mood before. So I will really say the reality over here. I went to him at around 10 p.m. where the mood problem was disclosed. I showed him the mood problem. He said, listen, boss, write this mood problem in your notebook at least 15 times. And I was like, really? That would solve everything? And he said, yeah, that will. However, you will write this 15 times in a scenario where this 30-page problem would be written in 15 lines. The next time you'll write it, you write it in 10 lines. The next time you write it is 5, then 3, then 2, and then 1. Any judge that you're going to appear before or you're going to present your mood to needs to know what you want in that one line. And that's what I learned the most from him. And that's what he taught me at that one moment I can never forget in my life is that 15, 10, 5, 3, 2, 1 rule. Any problem I took after that, you need to get your facts right. So write them down in a 15 liner sheet, then go for 10, then go for 5, then go for 3, and 2 and 1. That's what helped me the most as far as any moods or any current scenario, even if you talk about, would really take. You read the draft, you read 15 points on it, then 10 points on it, then 5, then 3, 2, 1.
yes. It seems simpler now. Now on this other side of the aisle, when we don't have to do it as a student, that these mood court problems, which we used to worry so much about. Like I used to rush for the deadlines and just finish
Oh
it, get it
madness.
under the wire, so as to not lose a point on the memorial. But this thing, it was exciting nonetheless throughout the process until you finish your arguments and everything, and the rush was amazing. But it is quite similar when you are in a courtroom. Like it
Yeah, it is.
prepares
It
you
is.
for all the rebuke, ragging, possibly anything coming your way by the judge or the senior advocates or the other sides. It helps you tremendously to take it all and still stay on point and
Yeah, yeah.
go forward with your argument any which way. Just push it through and you will figure it out eventually.
And as far as the moot court is concerned, I think courtcraft is something that you learn the most over there. And I don't know what moots probably taught me was even if your judge is not interested in you, you have to make the topic as his candy. You have to make it as interesting for him. You have to be as convincing as I don't know. I won't say entertaining because that would be a different scenario, but as fulfilling for him to really pay attention to you. Because in today's day and age, if you see some judge hearing a long argument, he'd probably sleep through it if you're monotonous. You have to have that court craft in a way to engage the judge, to engage your audience, what I would say.
True, agreed. Unless they are involved in the whole process of argument, they are not going to listen or pay
They're
attention,
not going to
and
listen.
they're
Exactly.
already decided beforehand. If they're not listening to you, they are listening to the other party, or they've already made up their mind. So you have
Yeah,
to
that
make
was
sure that
strategy
you
during a
listen to
mood. That was strategy during a mood that you either intrigue them to ask questions or you keep answering their questions and judging their frame of mind, which is tough. It's genuinely tough. You have to know that judge before you have to know his state of mind. You have to know if he's a silent judge, if he's a really a talkative one. You have to know if he's a really curious one or not. So that was one preparation that impromptu moods also gave you. Like suddenly sitting for a mood, okay, fine, I know a bit of the law, I know a bit of the facts, go and sit for it. That's something even this thing would do. Next, I would really like to go for is mock trials. I don't
Yes,
know.
yes, that is a very interesting topic in the sense. Usually, even as a student, I used to get confused between what's a mock trial and what's a moot court because to me they sounded the similar, quite similar.
Quite similar
So it
things, yeah.
could be the same thing exactly for all I know. So
Yeah.
let's just get into that and clarify it for the viewers.
So basically, the difference between a moot court and a mock trial is that in a moot court scenario, you are arguing as a final relief for any suit or for any matter that you're going. Now, this may come as a surprise for the first, second year students who've done those initial novice moots and everything, where you're supposed to argue a problem, where evidence has been led, where this has been done, that has been done, or possibly a writ that you are arguing. So this is done at a high court level or at a city civil level where the entire matter has been argued. But what happens before that is actually the most fun part. In a mock trial, what I learned, what ultimately the stage goes by, is that you have an opening, you have someone taking the chief cross examination, the actual cross examination, and the conclusion to whatever your cross is. Now, I have done basically criminal mock trials, but there can be civil and mock trials, and I don't know why people are not doing it. Probably they will be doing it right now, but I don't know. So, as far as mock trials would go, I think the most important scenario, the most important learning for a mock trial was witness training. Now, the way mock trials go is that you are given a problem, you have to you're given some point of evidences also, and those evidence would link to the accused over there. There are witnesses, and there is ultimately that special witness or that possibly going hostile with expert witness that will guide you to the process. Now, what I remember from my earlier mock trials was this death of someone in the prison, and the police inspector was the main accused, and obviously the witnesses were the havaldars and the other people in his cell and all of those guys. One of those guys ultimately would go hostile is something a scenario that we always assume, which obviously happens in some moot courts. They want to make it if they want to make it interesting. So this is how a moot court would go. A speaker would come, introduce the entire strategy that he's framed through his opening. He would ultimately say that, okay, through this trial, I am going to say that the accused has done this with this strategy, with this frame of mind, ultimately establishing a chain of events which he will have to prove through evidence. And that's where the second speaker comes in, where he has to take the chief of his witnesses. So, as a defense counsel, I would have my defense witnesses where I would prove that the accused hasn't done this at all. And this hasn't done this has to be told to the witness, has to be trained to him that boss, I am going to take your chief. And like this is the conversation what I have with the witness. That these are the questions I am going to ask you. These are what your reply should be. If this is asked, you should probably reply to this. And mostly a witness would know that, okay, I know what to say ABCD. But what if? And this what if scenario is something that mock trial basically taught me. Understanding the witness, understanding his background, understanding what his answers would be as far as the chief would be concerned. So I'll just explain the mood problem to you in a bit, so that everyone can get on board with this. So the problem basically is that on one fine day, this inspector kills this accused person, this a person who's in the jail, and ultimately gets blamed for it because it's custody, it's death in a custody. So now the inspector is the accused. The person who was supposed to who was supposed to get a trial has already died. The person witnessing are two of the Havaldars and two of his jailmates. So now I am talking to the Havaldar, who is my defense witness, who has to ultimately testify to prove that my client, who is a police officer, is really not is really hasn't done the crime. So they have to establish a scenario where they have seen something, but possibly show that the inspector shot him as a self-defense mechanism. So I asked him, "What have you seen? What? How was the day like? How was the inspector's nature like? How was he to criminals as far as behavioral traits are concerned?" The witness would answer that he was fine. He was always very calm. He used to treat accused as they're supposed to be. He used to beat them up as far as interrogations were concerned, but again, they would do it with permission and if need arises. So that's how you ultimately train the witnesses as far as your side was concerned. As far as taking the cross examination was concerned, that was the biggest task in a mock trial. You have to get into the head of the witness. You have to get information from him that he is possibly suppressing, that he really knows about, and get get the evidence in your client's favor. So now again, sticking to this mood problem that we have in hand, I would ask I would ask the two witnesses who were in the cell at that point of time how the prisoner would react, how the prisoner was ultimately in the cell for these 2 days. Was he a bit was he a bit suppressed in life? Was he a bit, violent in life? Would he attack you on a scenario? And that's how I got through and sailed through this entire trial. I obviously took the cross at that point of time and got his confessions. And there was something also as a expert witness, something like a medical practitioner, something like a sub constable who's on both sides, who's an expert on events. So he would, as a doctor, would testify that no, okay, he was fine, but he possibly could have been dead because of this scenario also. So it was so as far as the case problem goes, it was important for the doctor to testify that he already had a precondition. If triggered, he would really suffocate or he would die, which wasn't disclosed in his panchnama or in his case diary. So that was something that was to be extracted from the medical witness also, from the expert witness also. So as far as mock trials would go, you obviously had that witness training was the most important factor, where you had to tell your witness that this would get you into trouble, this would get you out of trouble, and there was a very thin line between what to say and what not to say. Relating that to the current scenario, where as far as civil trials go, there really isn't oral evidence that is really important. People, yeah, as far as the CPC amendment goes, you can now ultimately testify an affidavit, and everything that you've said in the affidavit would be crossed. You would be crossed on them, including your education qualifications, including why you're here, including if you have the power of attorney to it. So each and every ounce of evidence that you introduce in your affidavit would be questionable in the cross examination. I have not seen the earlier trials that happened during the pre-80 era, but this is what my seniors have told me. It was rather interesting at that point of time. And the witness used to say one thing, and after that 2 or 3 minutes where he is done with the chief, the cross would come and it would hit the witness that this is what I said. Oh shit, I shouldn't have said this. In today's day and age, The affidavit is structured and vetted by three or four advocates to make it as foolproof as possible, so that in cross examination the witness doesn't get killed. So that in a way has, save time is something that people say, but yeah, it has the self shift the sail through. That's it.
Personally, I think it's a good thing for the lawyers to have that structure in place, because otherwise the clients or the witnesses, they could go really
Oh, they
haywire.
could go really haywire. They
The
could go
training
literally
takes
haywire.
much longer that way. So I think that's a good thing. But
But
again, in light of justice, I'm still not sure. Probably this
I don't
how
know.
effective is it?
As far as my experience goes, I would really like a witness to be surprised. See, training ultimately is required for any scenario. If you are training him for a cross, you might as well train him for a chief. So,
Exactly.
taking the example that we were going through, if one of my witnesses has seen the truth, that truth should come out of his head in the interest of justice, in the larger interest of justice. Like I would see it that way.
Yeah, exactly. Okay. In that case, it does serve the purpose. True. Okay. So apart from these activities, these are like hardcore
These
law.
are these are very hardcore. Yeah, true.
Yeah. So where do you see these activities shaping up the lawyer's career? Like obviously you said the cross-examination, the methods involved, the court decorum and everything involved. All these
Everything.
things add to the student's life and helps them at least have a glimpse of what is coming for them in the future.
True.
So to
But
like
however, most lawyers, I mean, I don't know what the trend right now is. As far as I mean, this might feel really old, but 4 years ago, the trend was that you would go to a corporate culture, you would work in a big firm, and you would ultimately become a corporate lawyer, ultimately dealing in something marginal acquisitions, banking, or something of these scenarios. With that came competitions like negotiation challenge or client counseling, where in negotiation challenge you would sit with your opposite lawyer on a table and negotiate a deal for both your clients. Now that was another challenging scenario. I did a very few of them, but that was working towards a settlement and knowing that this matter is going to get settled, writing down the terms of settlement. This helped me a lot because today's day and age, I think, as far as civil matters are concerned, I mean, this would really hurt the lawyers here the most. But it's easier to get a matter settled. It's tough to set their egos aside. That's what ultimately really battles are all about, as far as civil is concerned. Once you put an injunctive suit on me, I would put another injunctive suit on you, and the battle goes on. So why not come on the table, settle the matter, in which both get a win-win scenario. And as far as negotiation challenges help, even the law ministry nowadays encourages mediation as a tactic. So yeah, again, negotiation and mediation are very drift apart, but yeah, that was one.
any yeah. Like these are hardcore, as I said. So apart from these, any other activities you were a part of, like which maybe shaped your life as a student, which led you to organizational or anything of that, some activities?
Yeah, organizing I would come to, but I forgotten one of those scenarios. Legislative drafting was one or another
Okay.
scenario. I'll talk about it in a while since you've questioned me about organizing. So there was this event in college which we used to organize called Legalies, and this I would really equate to where in my first 6 months of career I was I was in my space of you know becoming an advocate and bringing about your own firm. So as far as legalese goes, we had to advertise our college and generate funds for the event, which ultimately does go in the path of selling yourself as a lawyer as if how good are you as far as that is concerned. So the point number one in that was networking, which any lawyer would need, and that's what we used to do in legalese. That was the first base scenario. Establish contact with your previous advertisers or previous people who had done this for you. The generate funds. How do you go about it? So networking was possibly the biggest challenge as far as any event would go. Organizing all these stalls, organizing uh, events, competitions. That was something that legally taught me the most. So communication, that was the first thing. Second thing was advertising. Now you had to advertise your college as a whole and advertise the event that this is where you get the maximum footfall. This is where you advertise so you'll get the greater returns as far your product is concerned. So, I mean, bringing a parallel to you, we went to this mega cellular company for our event. I'll give you the spoiler. We didn't really give us any sponsorship, but we got treated well. We were in one of the finest restaurants in finest hotels in Pune, and the lobby, and we were waiting for the person to come. The junior marketing head had come obviously to us, who were the vice presidents or whatever of legalese. And the first question he asked us was, "How much is the footfall?" And I had to make a figure up, give him the basis of what I make the figure up on, and ultimately tell him that, listen, if you put up a stall over here, these X number of students will be interested in possibly buying your services or modifying them for your benefit. Selling a product is what I'm coming to. In today's scenario, if any client comes to me, I have to tell him with my expert legal knowledge or with the knowledge of my seniors as to what reliefs I can give that client as far as problem is concerned. What exact forum would you have to approach for these reliefs for the fastest way to achieve them? So similarly, I would tell that client, the cellular service, that if you set up a stall over here, you will have maximum reach. If you set up an announcements counter over here, that will get you reach. This is what we will do in our posters. In our every ticket, we will put your logo. In our every event, we'll announce your name. So those again negotiations uh, as far as the entire event would go, would shape you as a lawyer in a today's day and age scenario where ultimately you have to be your own marketer. You can't ultimately today even I have a label, but that's how a single working lawyer or sole proprietor would go for. That's what my expertise are. Like for example, a lawyer practicing in a Dadar court where he only deals with consumer matters is the king of that court. He doesn't need advertisement. But as a young lawyer and an aspiring lawyer, you would need that kind of expertise or that target reach of, this is what you have to tell the client. This is what you have to ultimately bring on his table and satisfy his needs with. The most important part of a festival also is budgeting. So if you guys are planning to open a new office at some point in time, you have to know your future expenses. You have to know how that entire event or day course will go, and that will require planning. So a 5 day event will ultimately take a month of your schedule, which I think planning I don't really have to explain because every step for every youngster today also requires a lot of planning. So yeah, that's what organization taught me as far as legal is concerned. And yeah, we since I've been introduced as one of those people who've also organized a photography club in college, we took the brave step of doing that, and it really went well.
Great. What about you were talking about legislative drafting, right?
Yeah,
So,
legislative
yeah, let's
drafting.
get to it. Like, what is it about?
So
What does it
legislative
help you?
drafting is basically when you are given a scenario where you need a certain law to be framed. Now I can tell you details about this because I was told that you can do this. This college in Mumbai organized this event in my final year of college, and which really interested me. It was drafting a legislation for stem cells and how you would bring about the control and effective utilization of a stem cell research. So, for that, obviously, you need to do this. Is the first step was research. Is that any other law exists? So we obviously went to the Drug and Cosmetics Act. We obviously went to the Medical Councils Act and researched if all of these practices were really defined or not. So what legislative drafting taught us was in that 30 pager, which was a limit sorrowfully. So in that 30 pager, you have to draft an entire legislation in which you define the acts that are to be controlled by the scenario. You set up an establishment which would be the administrative body of that control, and in which you would also set up a mechanism of penalizing people who have not followed that, and you would obviously set up an entire future scenario also, that in case this has happened, this is what you're supposed to do. So since our topic was stem cell research and stem cell storage, we defined what stem cells were. We defined who could do stem cells. We defined the license required and the requirements that one has to do before applying for such a license for stem cell research or stem cell storage. We define how centers could be different as research centers only or as storage centers only. We defined what could be stored as an embryo. We defined what could be and how long it could be stored. Now, obviously, we did not go into the scientific bit of it, but we laid a small generic foundation to how this has to be done. That, I mean, it's India, so you have to really lay down laws as specific as you could. But at the same time, if you keep them as generic, at the same time, if you keep it as specific, they really get very, very stringent as far as interpretation is concerned. So in the legislative drafting competition, we learned the most was while even framing an act or a sub clause, you have to be specific, but you have to keep it as general as you can, so that any person can understand it. Now, I would really bring it to the scenario that we were recently, as far as the Arbitration Act was concerned, and its retrospective effect. Now, the 2018 bill really clears it out that whatever happened, whatever was commenced earlier to 2015 is the old act, and whatever is post that is the new act. It has to be as simple as that, or else you'll have a savings clause, then you'll have another clause for interpretation of it. So now that is what we learned the most in legislative drafting. And of course, the importance of one legislature, even if how small it may be. Like something as the Aryan marriage, there is something called as the Aryan Marriage Act or something like that. It is a two-pager act. However, it has the four most important clauses that every act would have. It would have a preamble, it would have the definition clause, it would have the penalization clause, and it would have a savings clause. So that is something that was important as far as every legislature is concerned. And even today, while reading a new act, what I first see is, yes, this is what the intent of the act is. This is what the ultimate result of the act is. This is how it's defined, and this is why it is defined. So that's what legislative drafting really taught me as far as the legal career is concerned.
Basically, how to go about reading a particular act and taking what is the most
Yeah.
important
And
aspect
during my
of it.
internship with Karanjawala and Company, we also, laid the foundation of a bill for compulsion of birth and death certificates,
Okay.
which ultimately took effect into Aadhaar now. But yeah, that's how
Oh,
that's
that's interesting.
yeah, that's also I recently got to know that, oh, this is how it is going to affect too. So yeah.
Okay, that's an interesting take on it. So we are close to our 1 hour mark. So let's just. Are there any other activities which you'd like to mention? Like,
Yeah, there was judging all these activities also has been in our
how is
experience.
that different? Like being a student, I can imagine being nervous as hell at every point in time about everything. But when you are on the judging side, you realize how different the give and takes are. Like what you're supposed to really focus on. So how is
Yeah,
that?
in fact, I mean, I would possibly take this as a role, but judging was, in fact, when we used to judge as judges for novice or very judges as fitness, our professors made it very, very clear that you are not, that you have to judge them, of course, but you are in fact mentoring them. You have to shape their opinions about what matter they have brought before you, and to show the possibility of the relief that they are seeking. So judging ultimately was analyze self analysis. In fact, I would call it that. That okay, as a delegate of a model event, when I was chairing the session, This is what I would expect from a delegate. As a judge in a parliamentary debate competition, I would know where he went wrong, and this is how I would structure his arguments next time for. As a judge in a moot court, I would try to extract what he's trying to bring in the smallest possible time and pull him to the maximum extent where he is trying to explore that entire matter before me. So interestingly, I had just like almost 2 years ago. So there was this torch problem where this guy knew the law, where this guy knew entirely how his matter was placed, but that fear of stage or the fear of being judged was on him. So as far as a judge goes, you have to ease him up also. I mean, that's what a judge has always told me, that judges are not here to bring you down. They are ultimately over here to give you reliefs, to give you what you are praying for, and whether it is if it is possible for him to do so. So they are not your enemies, is what I'm just bringing about. There are seniors who possibly told you that nay, you have to spoon feed him, you have to sail him through your entire draft, you have to tell him ABCs of your matter. No, I would rather take it in a different way. Howsoever educated the judge would be, after 2 or 3 hearings as far as the mood goes, after 2 or 3 hearings of the matter, he knows what you're up for. He exactly knows what your line of argument is. He exactly knows what your plus points and what your minus points are. That's how he judges you. As far as the model UN goes, he knows what to expect of the committee. He knows that he has a stringent timeline for ultimately, building up a resolution. And as far as real scenario goes, the judges basic, the judges, I think a big salute to the judges today, that they are working more than 24 hours a day, where they come to courts before any lawyer does, that they read 90 matters a day before they do, and they know exactly on what page what is written. And I have seen this throughout 4 years of practice, that no judge can be taken lightly. No judge, not even a judge sitting in the Alwar district court, who possibly does not know to comprehend as well in English as you do. So never take that judge, or never take any person who's sitting in that four walls. He can do anything. That's
Yeah,
something I've
they're up
learned.
there for a reason.
Sorry.
They're up there for a reason.
Yeah, they're up for the reason. They're up there for a reason. True.
Yes. Okay. So we have one question basically about the legal system, like whether it's in a rut, and what do you think like the bar councils and the lawyers can do to help that?
On a personal level, I don't think it's in a rut. On a personal level, I think it's improving on a day-to-day basis. Yes, we have problems like corruption in the country. Yes, we do have a problem of selection of judges. Yes, we do have a problem of number of cases, but that will ultimately reduce, thanks to the tribunals in the country, thanks to the structure of laws that is taking place. What will never change is the population, and the expertise that a judge requires to become what he is. Now, of course, we have already talked of the good ones. There are a few bad ones. I won't name them, and God regret if I call them bad. But they have their priorities as far as the judge is concerned. Some want to finish their board, some want to finish their assignment. So, judicial system is in a mess as far as that part is concerned. Is where judges cannot understand what a lawyer specifically wants, and I would blame the lawyer also for that. That you're stretching the matter too much for the judge to understand, and that's where it takes a kickback. That you can't blame someone who's sitting there where you've not paid him, where he draws a minimum salary, and he's still doing that for you. And it's not that a judge does not care for you. I think we are better off than, as far as more than 50% of the nations of the world are concerned. I think we are a developing economy, so we will make it better. The problem of corruption in India is inevitable. That will or will not go. But the judiciary has done its job, and it will do.
Yes, I believe the most issue people have is the time it takes, but they don't realize that the time which is being taken is actually in their favor, because they don't want it to be rushed and taken it lightly. Like they
No,
want it to be
and let's not
examined.
forget, it's us lawyers who take the time. Okay,
That's true.
there's a
Sometimes
baby
it's
story.
on purpose and sometimes otherwise, but mostly that process is actually quite long. But the idea is to be able to deliver the justice eventually, then given a shoddy judgment prior, like in a fast track.
In the
So
past
that
track.
makes sense. Yeah.
No, as far as judgments are concerned, most lower court judgments would ultimately end up like this. The proposition lawyer said this, the opposition lawyer said this. I conclude in favor of the proposition lawyer. That's it. There is no application of mind. There is no appreciation of this. Okay, he said this damn good thing, but this sweet thing didn't really come through. So
Okay.
I mean, you need to understand the frame of a judge also. He has to sit there and decide on thousands of matters. This is the easiest thing he can do.
Yeah, sometimes they have to even write down their own judge orders, if I'm not wrong, in the lower course. So I can't imagine them
No, no.
writing it.
In the lowest court in the country, I mean, I would really not take names again over here. If an application is made, a handwritten order comes there, and if you ask for a certificate copy of the order, your application comes back, but there is this minor handwriting of the judge that comes in, which is the order. That
Okay.
is your certified copy of the order. And it's really shocking because this is the first time I went to a court and a certified copy. I'm like, this is my application. And he said, look behind the orders there. So that
That is a different take altogether. Okay, we've concluded when they come to an end of a session. Do you have any parting message for the students out there who would like to participate in the college activities and take the fullest advantage they can to
yeah.
pursue?
I would really request every one of you to participate as much as you can. Losing is not, I mean, you know, you might lose, but you might learn also. Ultimately, what the fear of losing is what comes as far as the participation goes. The fear of freezing at that moment, and what I would really appreciate is that try everything as far as college goes. Try getting into a moot court, try getting into a model event, try getting into a drama club, try setting up your own club, try getting into the debating club, try getting into the legal aid club for all I care. But don't waste your time. Internship is something that you have to do. But like a very good senior of mine and a very good friend of mine told me that what you will learn in one day of your job is what you will learn in the entire internship, because you take your job seriously at that point in time. Internship you're doing because you need to get your what is it called,
Certificate.
cgpas up or merits up,
Certificates.
or you need to show off in college that you've done so many internships. No, have fun throughout college through the activities. You will meet a lot of students throughout this, and you will interact the most and you will network the most through these activities. Model events take students places, take them to the model events, debates. Every moot court also takes you to a lot of other places. So traveling is there. That's one
That's a
thing.
fun experience.
Yeah, that's experience. And
Great.
as far as other activities are concerned, I would really encourage if you guys do something offbeat, which is what I did. I did photography as a hobby in college. I opened up a club for with common interests of people in photography, and it ran well. We taught a few. I think we made some changes. I think today a person taking a selfie would think, okay, yeah, that senior told me to take a selfie like this. That probably helps. Lightning helps. Make a difference.
Great. With that, we'll just sign off for today. Everyone, please keep watching An Hour with LawSikho. We'll come up with a new episode on Monday again. Till then, see you. Thanks, Devashish,
Thank
for
you.
coming to our show and giving us such a wonderful lecture on this topic. Most people didn't know much about how to utilize the activities in college and translate it into their career. I hope this will be very useful for them. Thank you for coming.
Thank you.
Thank you. Okay.